If you're considering filing a petition with the probate court to be the administrator or the executor of an estate, here's a few things you need to do before, during, and after the process. First, before you meet with an attorney, what you want to do is you want to gain access to the decedent's home so you can access and find all their important papers, look for financial documents, you're looking to see if there's a will, you're looking to see if you can find insurance information, deeds, rental agreements, any documents that may indicate that the deceased person, they operated a business. You may find documents about the ownership type and about if there are other members or partners in that business. So you want to gather that information beforehand because that'll give you a better idea of what steps you need to take, whether you simply need to file for permanent administration or permanent probating of the will so you can become the executor, or if you need to file for temporary administration, which would give you a more immediate access to the estate to make sure that the estate is properly preserved. The other things you need to do is forward the mail, particularly if you live out of state and there's not a lot of heirs or anyone that can help or visit the property on a regular basis. So you want to forward the mail. The mail is going to give you additional insight into the estate, particularly investment accounts, bank accounts, by way of the bank statements, and things of that nature that you will need once you become the administrator or executive of the estate. The other thing you may need to do, you may need to notify the Social Security Administration. You may need to notify creditors. You definitely want to notify the banks of the decedent's death so that the bank accounts can be frozen and anyone who has access to those accounts will no longer be able to withdraw money from the account. The final thing you want to do, you definitely want to make sure that the home is secure. If there's rental properties or someone living in the home that's not a co-owner of the home, you should give them notice that once you become the administrator or executor of the estate, that you're going to proceed with the eviction process. That way they have time to get themselves in order. And hopefully once you get the authority from the court, these people would have already vacated the home or be on the verge of vacating a home. So you don't have to start the whole 60-day notice and then eviction process. And you find yourself spending additional 3 or 4 months just to have these folks removed from the home. So once you've done those things, you then are preparing to file an open probate. So that means if there's a will, you're going to submit the will to the court for the court to make a determination that this is a valid will. If there's no will, you're petitioning the court to appoint you or another family member as the personal representative of the estate, also known as the administrator. If the family members can't agree on who's going to be the administrator, or if the estate has certain levels of complexity to it, if there's businesses or multiple homes or high dollar items, you may want to ask the court to appoint the county administrator to represent the estate in those situations. So once you become the administrator or you become the executor of the estate, then the next step is you need to marshal the assets. You need to gather all of the assets, and it's good practice for you to have some sort of inventory of what's in the estate, and that'll help you better plan for the proper administration of the assets. It also will help you understand what assets need to be secured as well. If a person had coin collections or precious metals or things of that nature, then you certainly will want to take possession of those and likely put them in a safe deposit box. Any brokerage accounts or bank accounts, you want to have those closed with the funds dispersed to the decedent's estate, and from there, you will have those funds held in a estate account. You're going to go through your process of notifying the creditors, and you're going to make sure all the bills are continued to be paid from the estate account, and you're going to make sure creditors are paid. And then once all of that has happened, there are no longer any outstanding obligations to the creditors, then you're going to do a final distribution to yourself if you're a beneficiary in the will or if you're an heir to the estate, and also to the other heirs. And any such distributions will be in accordance with the will or in accordance with Georgia law. That way you can keep yourself safe and protected and not run afoul of Georgia law or your obligation as the personal representative of the estate.